Welcome to Coffee and Regs.
Hi, everybody. Greg Hotaling with CSS. And today let's look at filings in the United States for your long holdings under Section 13 of the Exchange Act. So as you know, if you're a substantial shareholder holding positions on markets all around the world, you're going to have to file usually in the jurisdiction in which that issuer is either listed or registered or incorporated as a company. That's no exception with the US. If you have holdings on US listed markets, you'll have to file a Section 13 submission if you cross 5% of holdings. So the term is beneficial ownership is how they put it in the US. That's the term of art used. So if you cross 5% of beneficial ownership, the US is probably the most complicated such regime in the world. You know, I do a lot of this here at CSS, and I can say pretty confidently that it is, for better or worse. It's probably the only regime I can think of in which the type of shareholder you are, the type of firm you are, and your activity as a shareholder actually determines your filing thresholds, the percentage of the listed issuer that you hold, and also determines the deadlines. And that's in many different ways. You know, there aren't just 2 or 3 different permutations. There are more than that. So rather than make a video 8 hours long talking about all of that stuff, let's narrow it down to deadlines for 13G filings. So the 13G form is your shorter form. You're entitled to use it rather than the 13D, the longer form, if you qualify one of 3 different ways as an exempt investor. So you can either be a qualified institutional exempt investor, so the institutional investor exemption, or you can be qualify under what's known as the passive investor exemption. That's the second one. And the third one is, well, somewhat redundantly, it's called the exempt investor exemption. So how do those work? Under the institutional investor exemption, if you are a QII, qualified institutional investor, and there's a few different ways to qualify as such, but if you are a registered investment fund or advisor, those are some ways you can qualify. If you are one of those, if you qualify, you are entitled to use the 13G shorter form as long as you aren't an active investor. So as long as you're not trying to interfere or control the management of the issuer or the policies of the issuer through your investment. So you have to be a passive investor. The second exemption, really all you have to do is be a passive investor. That's really the only major requirement, as long as you're holding less than 20%. So that's a little bit less stringent, but as I'll get into later, you kind of pay for that with quicker deadlines in some cases. And then the third way, the exempt investor exemption, is for those that have acquired their securities by way of a Securities Act registration statement, or else acquired less than 2% of the issuer's securities within the last 12 months. Okay, so those are the 3 ways you can qualify to be an exempt investor. And by the way, this is something that when I practice securities law here in the US at a couple different firms, this kept attorneys up at night, whether a first-year associate all the way up to senior partners could be kept up at night for some of these things, because it can get very complicated, and it's probably not quite that onerous around the world as far as the amount of attorney billed time that you have to incur for satisfying these major shareholder obligations. In the US, it's probably the worst. I'm guessing that because I've seen myself, a lot of lawyers working late into the night on it, and I know for a fact that it's probably the most complicated regime in the world. So we have those 3 types of exemptions. So how do the deadlines work? If you file a 13G on one of the first pages of the form, you can check a box and it'll say 13D-1B or C or D. So 13D-1 is a reference to the provision under Regulation 13G, which is the applicable regulation that the SEC has put out under the Securities Exchange Act of 1934, Section 13. I know that was a mouthful. And that's why those 3 provisions are cited there. And subprovision B is for the institutional investor, subprovision C is for the passive investor exemption, and subprovision D is for the exempt investor exemption. So if you are a qualified institutional investor and you qualify for that exemption because you're passive as well, you don't need to make your 13G filing until 45 days after the end of the calendar year in which you have crossed that threshold of 5%. So that's good news. That makes it, pretty easy to make these filings. And the same is true if you qualify under the exempt investor exemption. And like I said, I've acquired to do that, you have to acquire less than 2% within the last 12 months or by way of a Securities Act registration statement. So for those two, don't need to file until 45 days after the end of the calendar year. A lot of people call it the Valentine's Day filing because of that. A lot of big firms do it as, very, very much a matter of routine for them because they know they'll have to make these filings at that time of year every year. If, however, you're a passive investor, meaning only a passive investor, and you don't qualify any other way, so you qualify under the passive investor exemption. As I mentioned earlier, you're paying for that sort of less strict way to be eligible for 13G because you have to make your 13G filing once you cross 5%, in that case, under that passive investor exemption within 10 days. Okay, so that's how that works. That's how those are the deadlines for filing once you cross 5%. In addition, you need to amend that 13G. If once you file a 13G, any of the information in what you've provided changes, then you have to make an amended filing. There's an exception to that, which is that if the issuer's number of outstanding securities has changed and nothing else has, you don't have to amend your 13G. But otherwise, if the information has changed, including acquiring or disposing of holdings or the percentage amount you own in the issuer, you need to make an amended filing. And in the cases of all three types of exemptions, you're entitled to do that at the Valentine's Day filing time, so 45 days after the end of the calendar year. It gets a little more complicated once you reach 10%. Then the deadlines can vary depending on the situation. You can be required to file immediately within 1 business day in some cases. In other cases, 10 days after the end of the month. That's a little bit different than 10 days after the end of crossing the threshold. So we're not going to get into that here, but certainly once you reach 10% and higher levels, those are things you need to consider. Another thing I should probably bring up is that if you have qualified as a passive investor, either under the institutional investor exemption, in which you also have to be a passive investor, or just under the passive investor exemption, which you have to be a passive investor and hold less than 20%, and you no longer are passive, meaning you've ceased to be a passive investor and you're now considered an active investor, you need to file a 13D fairly immediately. Within 10 days, you have to file a 13D. And there's also a cooling off period after that too, so you can't transact in the securities for 10 days after that.
This has been another episode of Coffee and Regs.